Good morning and welcome to the first episode of the new series of Gough Square Live. I'm Michael Coley and joining me today is Sabrina Goodchild. Today we're going to be talking about the new guidance issued by the ASA and the CMA concerning advertising and social media influencers. As more and more of us are now active on various social media platforms, certain users have attracted large numbers of followers or subscribers, often numbering in the hundreds or even millions. As a result, brands have been quick to seek to harness the power of such so-called influencers to promote their messages. For those with an existing public profile, this kind of influence is simply another part of a carefully curated reputation management program. However, many who have achieved newfound fame from the comfort of their own bedrooms may be unaware of the implications of monetizing an activity which for the most part they've hitherto seen as a hobby, including regulatory intervention. As a result, the ASA and the CMA have produced guidance for social media influencers which aims to help them to recognise when they're engaging in advertising and understand their obligations under the CAP code and consumer law when they do. As usual, we're running our live chat during the talk, so if you do have any questions or want to get involved in the discussion, please do join in.
Thank you, Michael. Now, the nature of advertising has come on leaps and bounds in the last few years. From adverts being limited to newspapers and the television, adverts are now placed on a whole host of online platforms. YouTube, Flickr, Pinterest, Tinder, free games downloaded from the App Store, you name it. Inevitably, that has meant that the law has had to keep up. The focus of this talk is on adverts that are made using social media, in particular Instagram, Snapchat, Facebook and Twitter, by so-called influencers, i.e. celebrities or individuals who have established a large following on social media. Could I have slide 1, please? These are all examples of posts made by influencers on social media. Indeed, these are all posts that have been complained about to the Advertising Standards Authority, the ASA, and the complaint has been upheld. The complaint that was made in all of these cases was that the post was not obviously identifiable as marketing communication, i.e. identifiable as adverts. So, what makes an advert in the context of influencer posts? Well, until recently, the law has not been keeping up with the phenomenon of influencer posts. You would have been hard-pressed to find reference to influencers in any primary legislation, and the CAP code, by which I mean the UK Code of Non-Broadcast Advertising and Direct Promotional Marketing, which supplements the law, certainly contains no such reference. That is until the ASA published on the 28th of September this year an influencer's guide to making clear that ads are ads. Could I have slide 2, please? This is a section of the ASA's guidance on what counts as an ad. Their definition is clear. The brand must have paid you in some way, and some form of editorial control over the content must be had. The guidance then provides further detail on what it means to be paid. It makes clear that this is not just limited to money and can include being given products, gifts, services, trips, hotel stays, etc., etc. The guidance also provides further detail on what is meant by control. It states, as a rule of thumb, if you weren't completely free to do and say whatever you wanted, whenever you wanted, then there could have been some level of editorial control by the brand. The most obvious form of control will be the brand specifying exactly what words must be used, at what time and with what photo. But control is very broad. In the ASA's ruling on war paint cosmetics on the 3rd of October 2018, the ASA found that whilst the written contractual agreement did not make specific stipulations about the content published by Ms Buckland on her social media, the contract required Ms Buckland to promote the brand and the products in a positive light at all times. Because that would in effect restrict aspects of Ms Buckland's control on her social media content, we considered that W7 had sufficient control over the content for the Instagram post in question to be considered a marketing communication. The ASA also specifies in its guidance that if a brand reserves the right to check the content before it's posted, then this could count as control, even if no changes are in fact requested. It should also be remembered that if an influencer posts about their own products or services, then this will count as advertising. This is clear both from the ASA's recent guidance and previous decisions. So, once something has been identified as an advert, what must an influencer or brand do then? The CAP code provides some assistance. Rule 2.1 states marketing communications must be obviously identifiable as such. Rule 2.4 states marketers and publishers must make clear that advertorials are marketing communications, for example, by heading them advertisement feature. Clearly essential reading for the next batch of Love Island hopefuls. The ASA's most recent guidance steps in again to provide very practical steps on what should be done, giving more detail to the CAP code. Approved wording includes ad, advertisement, advertising, and disapproved wording includes sponsorship, in association with, thanks to the brand for making this possible. Other things to consider are, can the hashtag ad, or whatever the chosen wording is, be seen without the consumer having to click see more? Is the hashtag ad visible when a mobile phone is used? Is the hashtag ad capable of being lost in a sea of hashtags? It is interesting to note that the ASA in its ruling on War Paint Cosmetics found that posting ambassador for brand in the bio of a profile was not sufficient because it was possible to view the post without viewing the profile and seeing the statement about brand ambassadorship. Finally, on this point, both the guidance and previous ASA decisions make clear that any adverts are the responsibility of both the brand and the individual to ensure compliance. Both will face criticism if they fail in this regard.
Well, thank you, Sabrina. So we've had a look at adverts, but the guidance from the ASA and the CMA also addresses sponsored content, i.e. content where there's been payment but no control, and so it isn't an advert for that purpose. Now, because of that lack of control, this type of content won't be considered an advert, but nonetheless could still lead to actionable breaches of consumer law. Let's take a look at slide 3 now. So we can see that this slide, if content is not an ad, the CAP code won't apply and the ASA will not pursue the brand or the influencer. However, we can see here a list of ways in which such content can still fall foul of the law. Failing to declare that content has been paid for example, is a banned practice under Schedule 1 of the Consumer Protection from Unfair Trading Regulations, which reads, using editorial content in the media to promote a product where a trader has paid for the promotion without making that clear in the content or by images or sounds clearly identifiable by the consumer. Now, additionally, anything which could be a misleading action or omission could also be a breach of CEPA. This might include giving the impression you're acting outside of a business, claiming to be a consumer, or hiding the commercial intent behind the post. The CMA has stated that it expects this kind of content to be clearly marked and has recommended the terms advertising feature or advertisement promotion for that purpose.
Thank you, Michael. Now, a word of caution. The identification of an advert as an advert is only the tip of an iceberg when it comes to compliance with the rules on advertising. It must not be forgotten that there are product-specific rules, for example, on medicines, health-related products, financial products, food, etc., etc. The list goes on. And there are also more general rules governing content, for example, regarding the substantiation of claims made, promotions, comparisons, and serious and widespread offence, to name just a few. And there are clear examples of where this is in fact forgotten. I recently came across an Instagram post by a B-list celebrity which depicted him exhaling smoke and telling his followers to use his discount code to claim £5 off your first box. This was followed by the rider, warning, some e-liquids contain nicotine which is addictive, intended for use by existing smokers aged 18 years, 21 years where applicable, or over, as alternatives to tobacco cigarettes. The rider continued, but also included, the company do not deliver on school grounds. Now, this rider was despite Rule 22.12 of the CAP Code, which states that except for media targeted exclusively to the trade, marketing communications with the direct or indirect effect of promoting nicotine-containing products, e-cigarettes and their components, which are not licensed as medicines, are not permitted for the following media: newspapers, magazines, online media, and some other forms of electronic media. So irrespective of whether this Instagram post was in contravention of the rules on identifying as an advert, In my opinion, there are clearly other breaches of the CAP code, which may in fact be more serious and should not be forgotten. And if celebrities are currently advertising electronic cigarettes, it's not beyond imagination that adverts will be placed by influencers for gambling companies, finance companies, etc., etc., all of which requires clear advice to be given both to the brands and to the influencers about what is and isn't permitted. That being said, as I'm sure you're all aware, the ASA's enforcement capabilities are limited. So Michael is going to discuss what enforcement action can be taken, by whom, and in what circumstances if a contravention occurs.
Yes, so where a content is an ad, that is to say there has been both payment and control, well, that will fall within the ambit of the ASA. Where there's non-compliance, the ASA can write to the brand and or the influencer and engage with them, requiring them to put the non-compliance right. For persistent offenders, there's a naming and shaming process by which their details are published on the ASA website. Now, while the ASA has no powers of its own to prosecute or bring proceedings, in the most serious cases it can refer the matter to an authority, such as trading standards, which can take civil or criminal enforcement action against either the brand and or the influencer as necessary. Additionally, the CMA has enforcement powers of its own. These range from informal measures such as consultation with the brand and or influencer and public awareness campaigns to bringing enforcement proceedings under the Enterprise Act and, in appropriate cases, bringing criminal prosecutions for breaches of consumer law, such as CPID. The CMA has the ability to investigate the market as a whole, and in fact this investigation is a follow-on to one which was undertaken in 2016 into the lack of differentiation between paid-for promotional content and editorial content. And it should also always be remembered that while this is guidance which has been produced by two specific authorities, general breaches of consumer protection legislation are always actionable on discovery by the appropriate investigating authorities such as trading standards. Well, that's a little overview of the guidance which has come out recently. As usual, we are taking questions through the live chat. We've had one question in advance of our broadcast today, and that's this. We've been asked how likely do we think it is that the CMA would take enforcement action in respect of the kind of contraventions that we've been talking about in today's episode?
Well, that's a good question. Now, the CMA obviously has enforcement powers, as discussed, but primarily it is a market regulator. So unless you've got big brands or groups of brands acting against the rules and what is required, in my opinion, it's quite unlikely that the CMA will intervene, and especially as against individual influencers, that enforcement action is quite unlikely. That being said, it is more likely that trading standards, upon acting from referrals from the ASA, where a complaint has primarily been made to the ASA, will intervene. And now, the way that that's likely to be dealt with is that it's more likely to affect individuals as opposed to brands, although that's no reason why brands can't be captured. But the division, in my opinion, would be CMA for brands, and more likely that trading standards taking action against individuals, with brands potentially being added as well. So, yes.
I think so. I think that we'll probably have to wait a little while to see whether any large-scale action is taken by the CMA in relation to the market as a whole. But I think on a day-to-day basis, it's likely to be individual influencers who are engaged with by the ASA, and probably in most of those cases, informal intervention is likely to resolve things. But of course, where it doesn't, there's ample scope for trading standards authorities to bring what will in effect be a relatively straightforward prosecution, the sort of thing they do day in, day out, for breaches of the consumer protection and fair trading regulations in respect of that.
And I should add that it's clearly on the CMA's radar at the moment. They're undertaking an investigation currently. So it's one to look out for. We haven't seen them previously, but it may be increasing in the forefront of the regulator's mind going forward.
That's right. Well, we haven't had any more questions on the live chat, so that may be a good moment to wrap things up for this week. Thank you to everyone who's joined us. Of course, you will be able to see this episode back on YouTube again for anyone who's missed it from probably this afternoon onwards. We'll be back with our next episode a week from today, featuring Lee Finch, who will be discussing limitation in civil claims. We hope you can join us again then, but for now, it's goodbye from me.
And goodbye from me. Thank you.
Thank you.